Ladies and gentlemen, welcome back to the Indie Zone. My name is Kathy. There has been substantial talk in the media amongst independent podcasters and within the community of the defense's offers of proof of alternate or alternative perpetrators. What does this term mean? This is typically, it is a defense that a defendant will raise, saying that I'm innocent, I've been wrongly accused of these crimes, the correct perpetrator or perpetrators is or are these other people or this other person. This issue came up in the state's motion in limine regarding alternative perpetrators that was filed back on the 17th of February 2025. They basically were looking for in limine, that means before trial, for a ruling. That is what a motion is. Motion is a request for a ruling, an application for a court order of the trial court, the finder of the law, for whatever the party who's filing the motion asks for. Here, the state raised what the legal standard is according to the state of a defendant raising alternative or alternate perpetrators. They have to comply with the rules of evidence. They cite to this Meister case, State versus Meister, and they state here that there have been literally thousands of tips that they have received, but the only one that appears to have panned out, according to the state of Idaho, was the tip that was received regarding Mr. Kohberger. Mr. Kohberger most certainly filed a response to this motion, and what the defense did is, back on the 17th of March, which is when the responses were due, the defense stated, and I want to draw your attention to page number 2. The state argues that literally thousands of tips regarding possible perpetrators were received by law enforcement during the course of the investigation, and that none of these tips were substantiated with the exception of information regarding the defendant. That, of course, is Mr. Kohberger, ladies and gentlemen. The defense goes on, the state is correct that over 45,000 tips have been disclosed and tips continue to come in daily. So this is the first time that we're learning as the public that at least as of March 17th, 2025, that law enforcement were apparently still receiving tips about these crimes. The defense then very confidently states, and I want you to take note of the presence of the word will, because that is not ambiguous. That seems to suggest that these things exist. Bottom of page 2, going into page 3. This case is full of alternative perpetrators. And then there's a footnote 1 here. See sealed memorandum in support of motion to suppress regarding genetic information, page 3. This, unfortunately, is a document under seal. This may be where the defense possibly gave some further details as to any alternative or alternate perpetrators. The response continues. The state has chosen to focus on Mr. Kohberger at its own peril. Mr. Kohberger will produce offers of proof relative to many alternative or alternate perpetrators in this case that will meet Idaho Rules of Evidence 401, 402, and 403. Many alternate perpetrators can be connected to the crime. Now, what did Judge Stephen J. Hippler have to say about all of this? In order to answer that question and to find that the defense was court-ordered to submit their offers of proof by the 14th of May, can be found in order memorializing oral rulings on motions in limine. This is dated April 18th, 2025. We have to go to pages 5 and 6. What the court says here regarding motions in limine, beginning at pages 5 and then going into page 6. States MIL, that's motion in limine regarding alternative perpetrator evidence. And it begins here by saying the state seeks an order prohibiting defendant from offering, quote, alternate perpetrator, end quote, evidence without first making a showing that such evidence is relevant and admissible under IRE, that is Idaho Rule of Evidence 401 and 403. These rules govern the standard of admissibility for alternate perpetrator evidence. And then citing to this State versus Meister, Idaho Supreme Court case, the court then says, mere inferences that another person could have committed the crime will most likely not be relevant, and if relevant, will still be subject to the limitations of IRE 403, end of quote. So we see here that the court is noting that mere inferences, some type of a guess, a hunch, a belief is not good enough. It has to be relevant, has to comport with the rules of evidence. Now let's go down to the next paragraph because the court's going to explain this a little bit more. While defendant is correct that such offers of proof can be made at trial, this case is not well suited to waiting until the time of trial to do so, particularly if defendant intends to submit multiple offers of proof. And this appears to be talking directly to Ms. Massoth's statement that there are many alternate perpetrators in this case and that the defense will be able to comport with Idaho law in submitting these offers of proof. Then goes on to say, laying the foundation for admission of the evidence will likely take a significant amount of time. After all, defendant cannot merely show another person could have committed the crime. Rather, there must be, quote, evidence, direct or circumstantial, linking the third person to the actual perpetration of the crime, end of quote. So we see there what Judge Hippler is going to be looking for in these offers of proof. Then, to quote Judge Hippler, to avoid undue delay at trial, defendant must present the offers of proof no later than May 14, 2025, so the matter can be addressed at the pretrial conference. The court will reserve ruling on the motion. There's a couple of footnotes here. Footnote number 5, the scope of the preclusive effect of this ruling includes suggesting that specific individuals looked at and cleared by law enforcement are alternate perpetrators without first complying with the showing required by this order. So this is talking to if the defense intends to point to people that have already been cleared, they still have to comport with the mandates of this order and Idaho law on what must be shown in order to successfully raise this alternate perpetrator defense. Now, yesterday was May 14th. In looking at the docket, there is nothing on the public docket regarding the defense's meeting of this court-ordered deadline. But there is also nothing on the docket where the defense has asked for an additional amount of time. That's called a motion for enlargement or a motion for extension of time to extend this hard and fast court-ordered deadline of May 14th, 2025. And in looking at the docket, as I have the many times I've had to do the podcast where we've looked at every filing in the case since its inception, I cannot remember the defense ever blowing a deadline. And in looking at the case summary page, there is a filing that says notice of compliance. And for some reason, the clerk of court did not address what this notice of compliance was for or even who filed it. This is very different from the other items that appeared on the case summary page yesterday, the 14th, which are all clearly state of Idaho filings. Now, why would this notice of compliance not have the name of the party. I'm speculating that this could possibly be the offers of proof. If not, there still were several hours in the afternoon, and the day is still available for the defense to file it yesterday. And today being the 15th of May, this is the final pretrial conference. It is scheduled to start commencing at 9 o'clock a.m. Mountain Time, Boise, Idaho time. We will also, a half hour beforehand, be presenting a very short presentation on the day's planned events, what we think will be addressed, what might be addressed, and other related matters. You can, if you would, click the Notify Me button on our live section. It's entitled People of the State of Idaho versus Brian C. Kohberger. We will most likely be doing something after the final pretrial conference to wrap up and to give opinions. If you have any comments, any feedback, please leave it here. Until next time, this is Kathy. Thanks for joining us today.